My name's Hagen, Jewell. I'm a barrister at the ground floor Wentworth. I have a kind of similar background to Jessica in that I see matters at the litigious end where arrangements between children normally and parents have gone badly, and kind of with alarming frequency I see the situation where the parents and the children have agreed to sell the family home and move in together, and the children resile from that agreement kind of down the track. So what I wanted to do is talk through what that process looks like from the start of the agreement all the way to resolution, and that resolution can be through mediation and it can also be through a litigated outcome. So as I say, I see these cases probably 12 to 15 times a year. Not all of them end up being resolved at court, but common to all of them is that I see people when they're I see the parents when they're very distressed and keen to get a resolution. So what people can do to protect themselves is that when they're having the conversation around selling the family home is to sit down with two solicitors ideally, one representing both parties, and draw up an agreement, draw up a deed as to what the agreement will look like, where the house will be, what the responsibilities will be between the parties. And then later, if the relationship sours, they've got the deed to refer to, they've got the agreement to refer to. I don't see that very frequently. What I see most frequently is that there's just an informal conversation, and then later down the track, an informal conversation, usually without much detail, later down the track, when the relationship falls apart, the parties are looking at each other to assert their rights, and there's very little to rely on. It can be, and I've seen this occasionally, it can be even after the new home is purchased that the agreement is drawn up between the parties. That's something that can be satisfactory, but in my experience it's better to do it up front, and then you have fewer things to worry about. So by the time you get to me, I'm looking at your remedies in law. Jessica's mentioned a few of them: unconscionability, contracts review, non est factum, but the real work in this space is done by the proprietary estoppels. The proprietary estoppels are interests in land that are created through agreement, and the court will give effect to that agreement if it can be clear enough. And what you have to do for the court is to demonstrate that you satisfy the elements of proprietary estoppel. There are 4 elements for a proprietary estoppel by encouragement in Australia as it's known. So to give an example from my practice, last year I did a matter where it was on the North Shore. The children agreed with the parents that the parents would sell the home and they'd move in together, and on the basis of that agreement the house was sold, they found a new property and they lived happily for 5 years, and then things went sour. In those circumstances you need to satisfy the court that there has been the agreement, there's been reliance of the agreement, and then detriment. There's also a 4th element in Australia that's being kicked around, but we won't talk about that here. So at that stage, if a matter has come to me, and at that stage what I recommend we do is we caveat the property. So we put a bar on anyone else dealing with the property so that you can commence proceedings and commence the litigious process. To give you a kind of insight into what litigation looks like in New South Wales, these matters are commenced in the Supreme Court of New South Wales. So these are the figures from the 2016 annual report for the court, and there's a 70% chance of resolution within 12 months at first instance, and then an 88% chance of a resolution within 2 years at first instance. and then a 91% chance of resolution at appeal. So what that looks like essentially is that 70% of matters are going to be resolved in the first 12 months that they're commenced. It's not super quick, but it is definitive. I want to talk about this because it relates to one of the recommendations in the ALRC, which recommends that there be a national tribunal. But the court gives you a rather definitive outcome, and there's a couple of specialist lists that you can approach if you find yourselves in one of these matters. One is that the court will grant you expedition, so it'll grant you an abridged timetable. You can get a matter on quicker if you can demonstrate, and the words are, an entitlement to take precedence over other cases in the equity division by obtaining an expedited hearing. So in my experience, not all the time, but in my experience, if you have an older person who's a plaintiff, the court will take that into account and grant you expedition. I have had matters where that wasn't enough. I've had a matter where I think she was 70 years old and she had MS but gone into remission, and that wasn't enough to satisfy the grant of expedition, but that matter was managed by the Chief Judge in Equity and it was dealt with within about 8 months anyway. So you can, it's not always a surefire bet that you'll get expedition, but there is also a list called the Real Property List, which is run by Justice Dark, and if you these proprietary interests fall within that territory, and if you approach him with your statement of claim, you'll find that the matter will be dealt with very swiftly in that list as well. There is mediation available in the litigious process, and my advice in these matters is always that you try and resolve a matter by mediation, and that you don't want to process to a litigated outcome. Litigation is difficult because there's no surety of what the outcome will be. And when you're in this situation, my experience is it's more beneficial to the parents to know that they can receive a lump sum of money and bring what is a very stressful process to an end. That's very important to have that kind of certainty and have that kind of quickness. Also, I find that I've been wildly successful for people before in the past and received, the full satisfaction of the claim and a costs order all the way, and they've been unhappy with the outcome. But at mediation, I find that where people craft their own outcome, they're always much happier and they're always much more responsive to the outcome. So there's a recommendation in the ALRC that these matters be dealt with by a tribunal. I'm not sure if you guys are across the recommendations as I am. I saw that and I was a bit alarmed by that. Tribunals, the argument for tribunals is that they provide you a quicker, no-cost resolution. These proprietary matters don't really lend themselves to being resolved in the tribunal. Normally there's a lot of money at stake, and tribunals can deal with significant sums of cash, but once you're in that process, you will find that you meet very stiff competition in the sense that people always instruct lawyers, and you don't get the sense of informality that the tribunal is looking to achieve, and you don't get that swiftness of resolution. To give you an example, I was instructed in a matter in the tribunal 2.5 years ago, and that's been appealed all the way to the High Court, and we're pending a decision. It's in a different context, but tribunals aren't the silver bullet to quick, cheap justice. They can tend to blow out what can be a protracted process. And there is last Thursday, the president of NCAT, a senior member, Dr. Renwick, and a judicial member, Bolland, decided that NCAT is a court for certain purposes in the residential tenancy space. So the jurisdiction of a tribunal in New South Wales is not certain and is always going to be subject to appeal. So these matters are better resolved in a judicial way. I think the best solution for outcomes like this is probably it would probably be better to expand the duties of solicitors. Jessica's talked about it, about how these matters ordinarily draw in a solicitor, because more often than not there's been one solicitor, he or she hasn't properly advised both sides about their rights, and the solicitor's conduct gets traversed in these proceedings. So more often than not, you not only have the unhappy parents and the unhappy children, but you have law cover sitting at that mediation table too. And a way of preventing that would be, is in situations like this, the solicitor doing the transaction would certify that there has been independent legal advice offered to the parents. Another way to resolve this would be to expand the specialist lists in the Court of New South Wales. That could be done quite easily and quite cheaply, because the practice notes that govern those are made by, or set by the Chief Judge and Equity Justice Ward and the Chief Justice of the Supreme Court, and they are committed to running a smoother path into the litigated process and out of it. And the other way to do it is that the machinery around this already exists, in the sense that Legal Aid do a tremendous job in New South Wales, and I'm privileged when they instruct me. And if they were funded in a more significant way, indeed the services like senior rights services, it would assist many more people, I think, than what would be inexpensive, and a tribunal, I think, without uncertainty. I've prepared a paper that kind of sets this out. If you'd like it, you can email me. It's helpful to have something that, when these matters come across your desk, that you can pick up and refer to. And I'm happy to take questions at the end. I too have a lot of grim war stories that, as Jessica indicated, that might help or illustrate how these matters process through the litigated process. Thanks.